Thank you, Your Honor. May it please the court, my name is Lynn Hartfield, attorney registration number 28961, and I represent the appellant, Jama Issa. The first thing I will address is the court's specific question regarding whether we could reach an agreement on the exhibit, which is a computer duster can that was seized from Mr. Issa. In my position below, of course, was that the court does not need the physical exhibit because the record really reflects that the can doesn't include the list of ingredients. The prosecution has never argued that it did. In fact, the prosecution argued it just didn't matter. The defense counsel did say that the can doesn't list the ingredients, and certainly the prosecution didn't say, yes, it does. So it was my position below or on appeal that we didn't need the can. However, after speaking with Ms. Rasmond, we have agreed that the court should have the can itself. I'm not comfortable with the court reviewing photos that the jury did not actually see, and I think Ms. Rasmond, if I'm quoting her right, she's not comfortable with stipulating that the can doesn't have the ingredients listed. The one thing I would say, the one other alternative, I did locate the manufacturer's website, and it does list the active ingredients on the website, and I can confirm that the active ingredient is difluoroethane, which is not one of the chemicals listed in the statute. Assuming the can either doesn't have the ingredients legibly written on the can or consistent with the manufacturer's website doesn't list any of the statutorily identified ingredients, I believe that settles the matter. The state has taken the position that they don't have to prove that the can actually contained one of the statutorily listed substances, and that we can just have the jury infer based on the fact that he inhaled something and then he behaved differently, that he violated the statute. I think that's just wrong. I think that's inconsistent with People versus Hard, which says it's really not enough to just say, well, we have a pill here, it looks like oxycodone, therefore he must have possessed oxycodone. And here, by the same token, it's not enough to say, well, he inhaled something and then he acted weird, and therefore we can conclude that he abused toxic vapors. The legislature defined that term, and the prosecution did not prove an essential element. If the court has no further questions on that issue, I'll move on to the second issue, which is,
Sorry, let me just interrupt you really quickly and ask you one follow-up question. I understand your position to be that us viewing additional photographs of the can that the jury did not have would be cause for concern. I understand your position on that. Typically, we would remand this to the district court to settle the record. One of the proposals that we might have is a transcription of the text that is on the back of the can, to the extent that you all can agree on that, rather than taking physical possession of the can, particularly in the current circumstances where we're not all even in the courthouse. We might have some concerns about taking physical possession of the can. Is there anything short of physical possession that would satisfy you, Ms. Hartfield?
Your Honor, I don't have any objection to a neutral person transcribing the ingredients if they are legible on the can. So that would also be an alternative. I want to make sure I'm not on mute. Moving on to the second issue then, this relates to the prosecutor's statement during rebuttal. Now, what happened, as the record reveals, is that defense counsel's argument, it was in part, why didn't the detectives investigate self-defense? Why didn't they investigate this? Mr. Issa had a big cut on his face, and yet the police immediately jumped to the conclusion that he had been the aggressor rather than the victim. The prosecution then said, well, you've opened the door now to us bringing in the fact that Mr. Issa had a chance to talk to the police, and he did not say he was the one who had been attacked. Now, what happened is the court then said, well, we don't really have to get into this Fifth Amendment issue, and then the defense counsel explained to the jury that Mr. Issa had stood on his Fifth Amendment right to not speak to the police. Then the prosecutor in rebuttal went in and highlighted, well, why didn't Mr. Issa talk to the police? Why didn't he tell them that that he had been defending himself? That's improper. 55 years ago, the Supreme Court gave voice to the Fifth Amendment right against self-incrimination and stated that people have to be warned that they don't have to speak to the police. And then at the same year, I believe, the court decided Griffin versus California and said it's a meaningless right if the judge or the prosecutor can then say to the jury, well, look, if he was really innocent, why didn't he say something to the police? And our Supreme Court has echoed that sentiment in Ortega, and that's exactly what happened here.
Counsel, even if we were to conclude that what the prosecutor said and did was improper, why wasn't it harmless in light of the rest of the record and the other evidence in the record?
It was not harmless because the record showed that, yes, Mr. Issa did admit that he was involved in this fight, and it certainly was, he was upset in the hospital when he saw the people who he said had just attacked him. So the reality is we have people with injuries. Both sides had injuries, and nobody investigated how Mr. Issa got his injuries. And certainly, just assuming that Mr. Issa's story was true, let's say that he had been attacked by two people based on his immigrant status. He runs away, and then the police grab him and his friend, and they put him in handcuffs, and they bring these people by, and they shine bright lights on him. And it's clear to him that the police have already made up their mind. Given that chain of events, it would make everything he did would make sense and would be consistent with self-defense. So I don't think this was a harmless error because his whole defense was self-defense. And the prosecution's comment said, well, if he's innocent, if this was self-defense, why didn't he say anything? And that was an impermissible comment on his silence, and it changed the whole case.
Thank you.
The second argument the prosecutor makes is that he opened the door and that defense counsel can't close the door. That's not correct. It's inconsistent with Cohen and Murphy, and those cases make clear that the opening the door concept is not just carte blanche to bring in any inadmissible evidence that the prosecution wants to bring in. It's designed to combat an unfair advantage that one party would get from providing an incomplete record. But in this case, defense counsel didn't get any unfair advantage because he got up and said, Mr. Issa didn't speak to police because he stood on his Fifth Amendment right. So any unfair advantage he might have gotten from saying, well, the police didn't investigate, was erased with that. And the prosecution did not then have the right to come in and bring in this really unfair comment on his exercise of his right to remain silent. Finally, oh, I'm sorry, do I see a hand? Yes.
Sorry, I guess I'm trying to figure out the significant difference between what defense counsel said about defendant not speaking and what the prosecutor said about defendant not speaking. How exactly were they different in specific ways?
Defense counsel explained why Mr. Issa was not speaking. He was not speaking not because he was guilty, but because he was exercising his Fifth Amendment right to remain silent in the face of police questioning. The prosecutor, on the other hand, implied that, well, if he was innocent, if this really was self-defense, then why didn't he speak to police and explain to them what happened? So those were two different ways of commenting on Mr. Issa's silence. Did I see another hand or no? I will move on to the final argument, and most of that is in the brief. I just wanted to highlight the fact that obviously this was a one-on-one show-up, which are disfavored. The issue then is whether under the Bernal factors, the identification was nonetheless reliable. One of the reasons this was not a reliable identification, and if you look at the court's order and you look at the suppression hearing transcript, is that we don't have a description from the male victim at all. We don't know how he described his assailants because that wasn't presented at the suppression hearing. Only what he said after the show-up was presented. The second part of that is that the other female victim, her description simply said there was one man with a Somalia shirt and one wearing a dark shirt. And it's significant when you look at the pictures of what Mr. Issa was wearing. He was not wearing a dark shirt. He was actually wearing a gray sweatshirt, which was fairly light. And it has a picture of Mickey Mouse on it, which would be the most salient identifying characteristic. And that really casts doubt on the Bernal factors about the reliability of the identification, because it casts doubt on the degree of attention that the witness had, and it casts doubt on the accuracy of the description. So when you balance all those factors, the only one that really weighs in favor of reliability is the time distance between the incident and the identification. So with that, if the court has no further questions, I would reserve the rest of my time for rebuttal.
Thank you. You may. Counsel, whenever you're ready.
Good afternoon. May it please the court. My name is Megan Rasband, registration number 43136, and I represent the people. I just want to start by letting the court know that I also have no objection to the proposal under CAR 10 that some sort of transcription of the can be submitted to the court, especially based on the present circumstances that we're facing. Just to briefly touch on the sufficiency of the evidence argument, it is my position that the evidence here was sufficient, even if those ingredients aren't on the listed on the can. And just talking about the test, it's looking at the evidence, both direct and circumstantial, when viewed as a whole and in light most favorable to the prosecution, that it's substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of the charge beyond a reasonable doubt. And if there is evidence from which one may reasonably infer an element of the crime, then the evidence is sufficient to sustain that element. And here, based on the testimony at trial, there was sufficient evidence that the defendant was guilty of this count. Both of the victims testified that they saw the defendant huffing from a can or inhaling from a can. I think the female victim described the defendant as maybe using a shirt as a filter, but she also then testified the physical manifestations that she saw, that he had huge eyes, that he was laughing hysterically, that he was jumping and was really hyper. The male victim testified that the defendant was quote unquote tweaked, and that he became aggressive after inhaling from that can. And then we also have testimony from one of the officers who testified that people use cans to huff and breathe in, and that it gives you.
Couldn't unmute myself. Sorry, and forgive me for interrupting. I just want to make sure that I understand. Is it the people's position that, and forgive me for saying it incorrectly the first time, Mr. Issa could be convicted of abusing toxic vapors if whatever he may have been inhaling on that evening is not one of the 15 specific substances that's listed in the statute?
So I think that the jury can infer from the defendant's behavior that what he was inhaling was one of those listed ingredients, because those ingredients are listed, those ingredients define what a toxic vapor is, and then you have the elements of toxic vapor, which also describes this kind of the behavior that the defendant then exhibited.
Following up on that question, is it the people's position that only these 15 substances and no other on earth can cause this reaction that the defendant had? so no other circumstance or no other substance besides these 15 could possibly have caused the physical reaction the defendant exhibited.
Not having a scientific background, I can't say that. I mean, the statute does list these 15 different ingredients in my research, and I understand that this isn't something that was, before the trial court, but the active ingredient, another name for it is freon, which is one of the listed elements, or one of the listed ingredients. But again, if that's not listed on the can and not before the jury, I think obviously we can only consider the evidence that the jury had. If I may just move on to the second issue, then the prosecutorial misconduct. It's a two-step review, and the first step looks at whether the prosecutor's conduct was improper based on the totality of the circumstances. And when you look at the totality of the circumstances here, that shows that the prosecutor was not improperly commenting on the defendant's right to remain silent. It's clear from the defense counsel's statement and closing argument that he was implying that the defendant told the police where the altercation occurred and that they had failed to investigate that information. And so the prosecutor's comment in rebuttal close was in fair response to that and not meant to comment on the defendant's right to remain silent. I think it's important to look at exactly what defense counsel stated during closing argument and the fact that he used the word opportunity, because that's something that then the prosecutor uses, in rebuttal. What he said is, my client, saying what happened here, did anyone bother to look? No, because no one gave an opportunity to be able to really say that. The opening the door doctrine is a fairness doctrine, and that the prosecution should have had an opportunity, and the judge agreed to be able to respond to that in some way. I disagree with counsel that that the defense counsel's comments following the prosecutor's objection somehow cured the misleading impression that the initial statement created. What he said is, now my client was under Miranda, so he said that he was struck by a knife to the paramedics. He didn't tell anybody else to go walk that path. Why would he? He's already in handcuffs. What difference does it make? That argument seems to be a justification for why the defendant didn't say anything, but it certainly doesn't clarify that the defendant had an opportunity to do so, which is exactly what defense counsel had asserted earlier, that he did not have the opportunity to do so. I think certainly looking at the prosecutor's comments in isolation, I can see why it would cause concern. But again, when they are viewed in context and under the totality of the circumstances, it was not improper. But to the extent that this court disagrees, because it was unobjected to, any review would be for plain error. And I would note, and I think I talked about in my brief as well, that defense counsel twice stated that the defendant had exercised his Miranda rights. There was testimony from, I think, 2 different officers that the defendant had been given his Miranda rights and had chosen not to speak with the officers. Also, when you look at the prosecutor's rebuttal closing argument, this comment was both brief and isolated. It was not a significant portion of the rebuttal. And I think there was also overwhelming evidence of the defendant's guilt based on both the victim's testimony, was consistent with each other, was consistent with the evidence. Again, I think the female victim's description of the defendant and the co-defendant were accurate to when they were then located by the police. There was a knife found near the defendant. There were air duster cans also found near the defendant. And the defendant's version of events just is not consistent with the evidence. And then finally, discussing the show of identification issue. The trial court properly denied that motion because the identification procedure was not unduly suggestive. One-on-one show-ups are disfavored, but they do not per se violate due process, and they may be justified in circumstances such as this, where the police need to quickly determine whether they should continue to search for armed and dangerous suspects. Obviously, I don't disagree with the fact that a person standing next to police or a person in handcuffs, that may be suggestive. But that's why that suggestibility is weighed against the five Bernal factors. Oh, sorry.
I'm wondering if you could address your opponent's contention that it was improper for the trial court to rely upon testimony that came out regarding observations at the hospital as opposed to before the identification itself. If you could address that part.
Sure. And I'm sorry, I can't remember why the police. I think the police didn't get a statement from the male victim before the identification. It was only from the female victim, but I think that still shows that the male victim very quickly and certainly said he was certain that the two gentlemen that were with the police were the ones that had assaulted him. And I think the fact that the later description is consistent with that shows his degree of certainty. I understand at that point he had already seen what the defendant and the co-defendant were wearing, but I don't think that makes his initial identification less reliable. I think both the female victim and the male victim, they both said that they were certain that those were the two that had assaulted them based on their clothing. So even though the male hadn't yet described that clothing, when he identified the defendant as the person that had assaulted him, he said he was 100% certain based on the clothes. And so I just don't think that because he had not yet described those clothes that undercuts the identification. And when you do look at those five factors, they weigh in favor of that this procedure was not unduly suggestive. The encounter started by the victim's car and it ended 50 feet away. So we know that the victims were in close contact with the defendant and the co-defendant. The female victim described the encounter, the assault, and the attackers in detail before the show of identification. Her description of the clothing, while she didn't say Mickey Mouse, it was accurate compared to the clothing that the detained males were wearing. Her and the male victim were driven separately to the location, so they didn't each know that the other had identified the males as the attackers. It was within 15 to 30 minutes of the assault, so it was fairly close in time. They were able to see the males and get it, it was lit and unobstructed, so they had a clear view of them. And they were both very.
Can I ask a follow-up question on that? Because there was some discussion in the briefs relative to the opportunity to observe. And I did read the people's brief as suggesting that the lighting around the show up itself was important for this opportunity to observe. My understanding of that element has always been the opportunity to observe during the crime, when the crime is happening. So the fact that the two individuals may have been well lit when they were part of the show up identification really isn't the consideration, right? It should be whether or not the male and female victim could observe the two suspects while they were being attacked or during the crime or immediately preceding the crime. Isn't that right?
Yes, I agree. I agree with that. The first factor is the witness's opportunity to view the criminal at the time of the crime. There was not a lot of testimony about that at the motions hearing. I think it can be inferred from just the female description, victim's description of the event that both she and the male victim had an opportunity to view the two males at the time, because it started out as a somewhat friendly encounter with the males asking for a cigarette. It just then became, this physical altercation. But I do think that the fact that the victims had a clear view of the two males is important, because if they can't actually clearly see who they're identifying, then I think that could go against the reliability of the identification. I'm sorry.
I have a question about your harmless error argument on this question. Is it any significance at all that at trial, the defendant testified under oath that he was there. He was the person involved in the altercation with the alleged victim. Does that have any significance at all to your analysis, your homicide analysis?
I'm sorry, Ms. Hartfield, I saw you shaking your head. Were you unable to hear the question?
I can't hear Judge Navarro very well. There seems to be a lot of interference.
Try again. Can you hear me better, Ms. Hartfield? Yeah, I'm having technical issues with my audio. I apologize. My question was simply to Ms. Rasband about her harmless error analysis. Does it matter at all that the defendant eventually testified under oath that he was there during the altercation? Does that make it harmless that his ID came in, IDing him as one of the people involved in the altercation?
So the reason I think that matters in a harmless error analysis is because one of the assertions that defense counsel makes is that the defendant may have pursued a different theory of defense had the show of identification been suppressed, and the record here doesn't support that. And I think that's one of the reasons why, because the defendant did testify under oath that he was at the scene of the assault. They endorsed self-defense before the suppression hearing, which I do recognize that there was a trial court order with motion deadlines, but it's really hard to get around the fact that one of the officers heard the defendant state to a paramedic that the guy had hit him or cut him with a knife. And so his own statements placed him there. And so just don't think the record supports an alternate theory of defense, nor do I think that can be pursued, understanding that the defendant testified under oath that he was there. And I see that I'm out of time. I would just ask this court to affirm.
Thank you. Ms. Hartfield, it looks like you have 3 minutes and 39 seconds remaining. Go ahead when you're ready.
Thank you, Your Honor. There are a couple of things that I wanted to address from the prosecution's argument. First of all, with respect to the toxic substances, the legislature chose to criminalize just those substances. If it had wanted to criminalize any substance that causes a person to be intoxicated or causes a person, when inhaled, to become to have behavioral changes, it could have done that, but it chose instead to list specific substances that it considered to be toxic substances, and we have to go with what the legislature's intent was. The second point I wanted to respond to was this idea of the defendant having the, quote, opportunity to speak to police. That is exactly what the Fifth Amendment protection against self-incrimination is about. In every case when someone is arrested, they have the, quote, opportunity to set the record straight and say their version of events. What we've seen, of course, is that can turn against the defendant because his words can be used against him in ways that he didn't anticipate. We have obviously issues with when defense interrogations are not video recorded. There can be misunderstandings. There can be misrepresentations in police reports. And for that reason, of course, many defense lawyers recommend that nobody ever go and talk to the police when they are arrested. So commenting on his opportunity to have spoken to the police and given his defense is exactly what the Fifth Amendment is designed to prevent, and what the rule against commenting on that is designed to prevent. Now, whether it's plain error, I would note that the court has often found plain error in situations where a defendant or a prosecutor comments on the defendant's fundamental right to remain silent. That is true in the cases I cited in my brief, but I also noticed that there were a couple of other very recent decisions, which I can provide the court with supplemental authority. But I think it's only for the point that it is not rare at all for a court to find plain error in a situation like this, where a prosecutor comments on a fundamental right. Finally, the prosecution's argument that the show-up identification was not harmless, or was harmless error, excuse me. The way that this works is that the court asks the defendant to submit affirmative defenses, any affirmative defenses, long before the case really gets going, in order to protect the right to to put forth whatever defense might possibly be there. Many defense lawyers will file a motion that says, well, we'll do alibi, we'll do self-defense, we'll do whatever, just to preserve that. So in this case, of course, the state had the burden to prove Mr. Issa guilty beyond a reasonable doubt. And the issue here is, without that identification, would they have been able to do that? When the defendant got an unfavorable ruling on that, he then put his self-defense case on, and there's nothing he did that was improper there. And so the error in admitting that identification.
Just to follow up on that, what is your response to counsel's argument that Mr. Issa's contemporaneous statements, albeit to the paramedic on scene, placed him at the scene, and whether or not that would have affected the ability to assert, you know, an alternate suspect defense, for example?
The issue would not necessarily have been an alternate suspect defense, but whether the strength of the evidence when the two eyewitnesses can't identify him in court. These eyewitnesses were quite candid. One of them actually said, you know, I don't even know. I mean, all Somalis look alike to me, so I don't even know if this is the guy. That's fairly powerful testimony that I think a jury would have had some skepticism. And the jury's questions, frankly, during the trial and the deliberations showed that they were paying close attention, and they were not necessarily that convinced that this was an open and shut case.
Great, thank you. All right, counsel,
like I'm out of time.
you are, and thank you. I gave you a few extra seconds to respond to my question. Sort of unfair for me to throw that at you at the end. Counsel, thank you very much, both of you, for your arguments. They will assist us in resolving this case. The case will stand submitted, and a written opinion will issue in due course. Thank you.
You may begin when you're ready.
Thank you. My name is Mike McConnell. I represent Centura and St. Anthony North Hospital. And our position is the trial court erred by denying the hospital's motion for attorney's fees and costs because it ruled that the phrase attorney's fees must be used in the contractual fee shifting provision in order for that fee shifting provision to be deemed valid. Before I address that issue, I wanted to quickly address the issue of costs. This court's May 28th opinion, I would submit, indisputably makes the hospital the prevailing party, which was contrary to what the trial court concluded below. So at a minimum, we would submit the trial court's order denying costs under Rule 54D must be reversed and remanded for determination of the amount of costs because the hospital is now the prevailing party. To address the attorney's fees issue, the trial court erred by ruling that the hospital was not entitled to either fees or costs under the contract. And a brief review of the facts in the contractual language, Ms. French signed the contract 3 times before her surgery. And one of the things it said was, quote, "I agree to pay all reasonable legal expenses necessary for the collection of any debt." Ms. French also signed the patient bill of rights 3 times before her surgery. And in it, she acknowledged it was her responsibility to understand her own insurance coverage. As the court noted in footnote 7 of its May 28th opinion, Ms. French was informed by her employer that a hospital may send a balance bill, and her insurance in that event would provide her with a lawyer to dispute the hospital bill. So Ms. French knew her insurance would provide her a lawyer to oppose a hospital's attempt to collect a balance bill. And we would submit common sense would dictate that if Ms. French and her insurance refused to pay a bill and hired lawyers to oppose a bill, then it would be necessary for the hospital to hire lawyers too. The application of standard rules of contract interpretation to the language in the contract show that we would submit the contract language is not ambiguous. The hospital is entitled to an award of all reasonable legal expenses necessary for the collection of Ms. French's debt. We would, yes.
Mr. McConnell, what do you do with the cases such as Morris versus Belfour and the Butler decision as well, all of which have language that say that a fee shifting clause must contain the phrase attorney fees?
I would submit that they don't say that exactly. What they say is that a fee shifting provision must communicate that attorney's fee, that the contracting party would be responsible for attorney's fees. Both Butler and Morris also say that formulaic language is not required in order for a fee shifting provision to be valid. So our position is that if you read all of the words in the fee shifting provision and place them in the context of this case, Ms. French, the contract clearly communicated to Ms. French, and she agreed that she would pay all reasonable legal expenses necessary for the collection of a debt, and that would include, not exclude, attorney's fees. I hope that answered your question. Okay. Yes.
And I have a follow-up question, which is that, I mean, the contract was created by the hospital, so the hospital could have readily said all reasonable legal expenses, including but not limited to attorney's fees. So to the extent that there's any ambiguity, why should it be construed, not be construed against the hospital rather than in favor of the hospital?
But two things. One is I would submit that it's not ambiguous, that there has been no alternative interpretation posited by Ms. French that the language all reasonable legal expenses necessary for the collection of a debt does not somehow include attorney's fees. And if the rule that formulaic language is not required in order for a fee shifting provision to be valid, then I would submit language that clearly and unambiguously includes attorney's fees, even if it doesn't use the words attorney's fees, is enforceable and valid. So some of the pertinent rules of contract interpretation that I think are dispositive here are that the words in a contract must be interpreted in accordance with their plain and ordinary meaning, that contracts must be interpreted using common sense, and that words in a contract cannot be interpreted in isolation but must be read together. Dictionaries can be considered to assess the plain and ordinary meaning. And again, when it comes to the validity of a fee shifting provision, there's no formula for language that's required in order for the provision to be deemed valid. And I would also note, and I would submit that this is important, that in essence, the trial court ruled that under the American rule, the fee shifting provision in the contract is invalid because it did not use the phrase attorney's fees. However, many of the Colorado cases discussing the American rule don't use the phrase attorney's fees. They use the phrase legal expenses, just like the contract here did. So an example is the Allstate versus Huzzer case. And in that, the Supreme Court in that case said the so-called American rule requires each party in a lawsuit to bear its own legal expenses. The Bernhardt case uses exactly the same language, and many other decisions quote those cases and that language too. So we would submit that this demonstrates that the Supreme Court understands the plain meaning of legal expenses includes attorney's fees. And again, there has been no alternative interpretation, a reasonable alternative interpretation that takes into account all the words of the contract that is an alternative to the interpretation we are proposing. So when one examines the contract provision in its entirety and gives effect to all of the words in it, the provision unambiguously includes attorney's fees. Now, because paying lawyers is unambiguously within the phrase all legal expenses necessary to collect the debt, we would submit the contract communicated to Ms. French that she would be obligated to pay the hospital's attorney's fees and other legal expenses if she failed to pay her bill. And that is all that's necessary for the fee shifting provision to be valid under Butler and Morris. And if Ms. French, I would note, if Ms. French wants to argue on remand that either no attorney's fees at all were necessary to collect her debt, or that there were significant tasks that the lawyers performed that weren't really necessary to collect the debt, she's free to do that. And the court would need to make a determination about that as part of enforcing the contractual provision. But in order for the provision to be valid at a threshold level, we submit that Colorado law does not require the phrase attorney's fees to be used, and that an interpretation or a ruling to the contrary would require the court to overrule Butler and Lemke's admonition that there's no formulaic language required, because that is clearly a formulaic language. Yes, sir.
Thank you. Sorry to interrupt you. I just wanted to make the point because, you understandably have been repeatedly referring to this no formulaic language part of Morris. But the very next sentence in Morris, after that sentence, is the fee shifting provision must specifically refer to attorney's fees. So how does your argument square with that portion of Morris?
Because I would submit that the words attorney's fees do not have to be used in order to comply with that provision. If you read that part of the decisions altogether, there's no formulaic language, but there must be a specific reference to attorney's fees. I would submit the language in this contract, all the language that says all reasonable legal fees necessary to collect a debt unambiguously includes attorney's fees and therefore specifically refers to them. I would also point out that the town of Alma case is the only Colorado case, at least that I could find, that involved a fee shifting provision that used the phrase legal expenses. And the court, and that case was considered by both the Court of Appeals and the Supreme Court, and they did not rule that the use of the phrase legal expenses and the failure to use the phrase attorney's fees made that provision invalid. There were a number of other issues in the case, but it would have been easy if that was the law, that the words attorney's fees have to be used in the town of Alma contract. They were not, and nevertheless the court held that the fee shifting provision was at least remanded for determination of whether the fee shifting provision was enforceable. There is authority. For an example is the air turbine case from the Federal Circuit that we cited in our reply brief. That specifically addresses the phrase legal costs and expenses as opposed to the phrase attorney's fees, and holds that it satisfies the requirement of having a specific reference to what is getting shifted. And so I'll reserve the rest of my time if that's okay.
You may. You have just under 3 minutes. And if Mr. Alderman is ready, we are ready to hear from him.
Your Honors, may it please the court, my name is Chris Alderman. I've been admitted pro hoc vice to this case, and I appreciate the opportunity to appear before you and argue this appeal. I want to be clear because this court and this panel's decision from last week has a big impact on what we're arguing today. The issue on appeal is obviously whether the trial court erred when it denied the motion for attorney's fees and costs in light of the judgment that was entered on the jury verdict. I understood Mr. McConnell's argument to be that they think the issue of cost and prevailing party should simply be remanded. I don't believe that the issue of the prevailing party is at issue today. To the extent it is, it should be limited to only what has been briefed and appealed, and that is who's the prevailing party based on the judgment that was entered. To the extent that Centura wishes to argue that it should be declared the prevailing party, the mechanism for doing that is under Rule 60. It's Rule 60B4, which allows a party who wants to challenge a prior ruling based on a reversal of the underlying judgment to move for that relief in the trial court once it's been remanded. There is a case which is not cited in the briefs because obviously none of the parties have been confronted with this issue. It's called Oster versus Back, B-A-A-C-K. It's 31 P3rd 546. It's a 2015 Colorado Court of Appeals case that is not directly on point, but I think suggests pretty clearly that the way to challenge an attorney's fee ruling after reversal of the underlying judgment is through Rule 60 rather than through an appeal. So with that, there were two issues appealed. The first was, did the trial court err in deciding that that Centura was not the prevailing party? And again, for reasons I just explained, I don't think the court needs to decide that issue today. The second issue on appeal, and the one that Mr. McConnell spent the vast majority of his time on, whether the trial court erred when it decided that the hospital's admission form doesn't specifically refer to attorney's fees and therefore is not a valid fee shifting clause. I'd like to spend the majority of my time on that question as well. And I'll turn to that. That question obviously was appealed. It was decided by the trial court, and the decision by the trial court with respect to whether the admission form includes an obligation to pay attorney's fees is wholly independent from the underlying judgment that was reversed. So that seems to be squarely before the court. On that issue, the trial court correctly determined that the hospital's admission form does not contain an enforceable fee shifting provision simply because it does not refer to attorney's fees. The Butler versus Limbeck and Morris versus Belfour cases that Judge Casebolt brought up do specifically say that enforceable fee shifting clauses don't necessarily require formulaic language, but they must specifically refer to attorney's fees. In Morris v. Belfour, the court said that the reason for a specific reference to attorney's fees is to clearly inform the parties that an award of attorney's fees is contemplated. There is a Court of Appeals case from 1999, which is about a decade before Morris and Butler, which says that the phrase legal expenses needs to be remanded to the trial court to determine whether it includes attorney's fees. And that decision comes before Butler and Morris adopted this bright line rule that says you have to specifically refer to attorney's fees. So back in 1999, before that rule had been adopted, the court said this is ambiguous and requires remand to the trial court. Given that the court thinks that phrase is ambiguous, and now there's a bright line rule that says you have to specifically say attorney's fees, then I think it's pretty clear that Butler and Morris control here. The admission form here falls short of the level of specificity that's required by Colorado courts. The way to refer to attorney's fees is simply to say attorney's fees. The hospital's admission form obviously does not say attorney's fees. It says, quote, "I agree to pay all reasonable legal expenses." We simply are pointing out the well-established law of Colorado that requires specific reference to attorney's fees. And again, Censura's admission form does not. Censura is relying on some language in Butler that says I'm sorry, Judge Navarro.
Sorry to interrupt. I guess I want to test your argument that the contract has to mention the phrase attorney's fees. What if it said, pay whatever the attorneys charge for their services? That wouldn't be good enough because it doesn't mention fees. And if it would be good enough, how is that different from expenses?
Well, I think the actual language in Butler answers that question. I believe that Butler was trying to adopt a bright line rule that says you have to refer to attorney's fees because that's how you refer to attorney's fees. And if you read that language, and I know I have a short amount of time, but this is important, and I think Butler does conclusively answer this question. So I'm going to read the language. In Butler, it says, "The lease does not contain typical language that provides for fees and costs to the prevailing party. Nevertheless, we have found no authority requiring that there be formulaic language in a fee shifting agreement, so long as it clearly informs the parties that a breach of the lease may result in an award of attorney's fees. In fact, a number of courts in other jurisdictions have awarded attorney's fees based on clauses with varying language, provided that such clauses specifically refer to attorney's fees." And then from there, the court in Butler cites 3 cases from other jurisdictions. It cites 2 cases, one from Missouri and one from New Jersey, where the courts in those states held that fee shifting clauses were enforceable. And the parentheticals that the Butler court put into that opinion make it very clear that the language in those two clauses from those two different states is very different, unified only by the fact that it included the phrase attorney's fees. Then the court, through its citation, instructed you to compare those two cases that were enforceable fee shifting clauses and contained the words attorney's fees with a case from Illinois, which did not include the word attorney's fees. In that case, there was a clause that provided a management company would be responsible for, quote, all collection costs. And that was not an enforceable fee shifting clause. And the parenthetical in Butler says it wasn't because it didn't include the phrase attorney's fees. So that's a long way, Judge Navarro, of answering your question. But I think all collection costs is very similar to the hypothetical you posited, which could be construed in a very broad way to include attorney's fees, but doesn't say attorney's fees and doesn't comport with the bright line rule that Butler adopted that you have to say attorney's fees. And just to be clear, I'm not talking about these cases from Missouri, New Jersey, and Illinois to suggest that the court go out and look at those and use them as persuasive authority. I'm talking about those cases because they're specifically cited by Butler for the purpose of saying we have a bright line rule now that you have to say attorney's fees because that's how you clearly put a party on notice that there's an award of attorney's fees contemplated. The Butler court was pointing out that there are a variety of ways to construct an obligation to pay attorney's fees as long as you actually use the words attorney's fees. Centura has also asked the court to relax these specificity requirements because legal expenses has been used by, I believe, the Supreme Court and the Court of Appeals to mean attorney's fees. And they say that's a legal term of art and that it has a technical meaning. The problem with that argument is that Ms. French is not a lawyer. There's no evidence that she has any idea what the legal term of art means, if it even is that, or to know the technical meaning. Ms. French dropped out of high school. She got her GED when she was 23 years old. She worked, at the time of the trial, she was working as a clerk at a trucking company and held similar positions throughout her life. So there's no basis to ignore a bright line rule that clearly establishes what has to be in a fee shifting clause to instead take a legal term of art and put it into a admission form that is between two non-lawyers. But in any event, Butler just conclusively resolves this issue about what's required in the attorney's fee clause, and there's not the word attorney's fees in the hospital's admission form. So to me, we've got just a clear case where there's a bright line rule that the hospital has not complied with, and it's not entitled to collect attorney's fees, regardless of who may be the prevailing party on remand, or regardless of any other decisions out there. It's just as simple as the way to refer to attorney's fees is to say attorney's fees, and obviously the hospital knew how to do that and should have if it wanted to collect attorney's fees. I see that I've got about 4 minutes left, and I want to go back, unless there are further questions on the whether the fee shifting clause at issue entitles Centura to attorney's fees. I'd like to go back to why I think the court should not enter an opinion on who's the prevailing party. So as I mentioned before, Rule 60 affords a party the opportunity to challenge an attorney's fee ruling if the underlying judgment is reversed. That's the situation that we have here. In the Oster versus Back case that I mentioned earlier, the Court of Appeals held that when the court issues its mandate, then the court reacquires jurisdiction to act on that mandate. And then when the underlying judgment is reversed, which has not happened, an attorney's fee award that is dependent on the reverse judgment for its validity is also necessarily reversed and becomes a nullity. And then that party can challenge the attorney's fee ruling by filing a motion under Rule 60 and arguing that it's the prevailing party given the mandate of the court. That is the case here to the extent that Centura wants to argue it's the prevailing party based on the Court of Appeals ruling from last week. To the extent this court evaluates the prevailing party, yes, Judge Navarro?
Thank you. I just want to make sure I'm following you. I mean, we have raised in the briefs here the question whether the hospital was a prevailing party. So it's clearly before us. What authority would we have to ignore that issue and not address it?
That's a good question, Judge Navarro. You could address it, but given that the issue that was appealed and the one that is briefed and before the court is whether the trial court erred when it entered its ruling based on the underlying judgment, I think the only way to address it is to evaluate who was the prevailing party at the time that the trial court made that ruling, which is before the reversal of the Court of Appeals.
So we would address it on the merits and completely ignore our decision from last week at the same time?
I don't suggest that the court does that, but to the extent you're going to address who's the prevailing party, it can't be based on a decision that was issued last week and that the parties haven't briefed and that was not appealed. The briefs don't include an appeal that says Centura is the prevailing party because we won at the Court of Appeals. There's another reason not to evaluate who's the prevailing party now, and that is as this panel recognized, the issue in the prior case was an issue of first impression, hotly debated between the parties. I don't think anyone on the panel would be surprised if Ms. French seeks review of that opinion. So it doesn't make any judicial economical sense to evaluate that now. Further, the last line of the opinion that was issued last week said that the court can entertain motions for relief from the judgment. There is a affirmative defense of unconscionability that would be raised by Ms. French if we got back to the trial court and the judgment was entered as directed in the Court of Appeals. Thank you, Your Honors.
Thank you. We've got a short rebuttal, 2 minutes and 55 seconds. Mr.
Thank
McConnell.
you. Your Honors, on the fee shifting provision, I'm going to focus on that issue. The rule in Colorado is clearly, and has been repeatedly stated, contractual fee shifting provisions are generally valid. There is no Colorado decision that has ever announced that there's a bright line rule similar to what Mr. Alderman's advocating. The way to determine the validity of the contractual fee shifting provision is to apply standard contract interpretation principles. And the argument of Ms. French violates standard contract interpretation principles. To assert that the words attorney's fees must be used in order to satisfy a bright line rule ignores the purpose of the rule announced in Butler and Morris, which is that the contract clearly communicate that one of the expenses that the contracting parties are shifting are attorney's fees. The words attorney's fees don't have to be used. There are many ways to communicate that unambiguously, and this contract did that. Ms. French has not offered any kind of contract interpretation analysis. And if I would submit you applied standard contract interpretation principles to the language in the contract, which is all reasonable legal expenses necessary to collect a debt, that attorney's fees are part of all reasonable legal expenses necessary to collect the debt. That is unambiguous. Again, we haven't heard today an alternative interpretation that would create an ambiguity. So focusing on the language that was used as opposed to alternative language that wasn't used, I would submit the court should find that this fee shifting provision is valid and enforceable. It's unambiguous, and the words in the contract should be enforced. That would require reversal and remand of the denial of the motion for attorney's fees and costs. Thank you.
Thank you. The court thanks both attorneys for your fine arguments. The case is now deemed submitted and an opinion will issue in due course. Thank you both. We are concluded with today's arguments.
Thank you.
We'll begin with you, Pat.
Your Honor, are you able to see me? This is Carmen Moraleda.
Yes, we are able to both see and hear you.
Okay, because I can see you all, but I cannot see myself. This is my first virtual argument, so I'm wondering whether this is supposed to be this way.
No, it took a little bit of time for you to pop up.
May it please the court. My name is Emmeline Winkelmeyer, attorney registration number 48799, and I represent Robert Christopher Diaguero. I plan to focus my argument on the first issue. However, I'm prepared to answer questions on all the issues. So turning to the first issue, the expert testimony from the domestic violence expert. First, a little background. This is a self-defense case that hinged on credibility analyses by the jury. Mr. Diaguero and his then girlfriend got in a fight in 2015. Afterwards, both of them called 911 and each gave conflicting versions of events, essentially blaming the other and both mentioning that they believed the other person was calling the police. Afterwards, Mr. Diaguero's girlfriend, Ms. Boykin, changed her testimony. By the time of trial, she gave a version of events that supported Mr. Diaguero's claim of self-defense. Instead of letting the jury evaluate the change in Ms. Boykin's testimony using its common sense, the prosecution admitted the testimony of an expert in domestic violence who testified about the dynamics of power and control in domestic violence relationships, a cycle of violence, and victim recantation. However, there was no basis for this expert testimony. Instead of letting the jury evaluate whether this is a once-in-a-lifetime event, this expert testimony cast Mr. Diaguero as an abuser and suggested that there was a history of violence in the relationship. Because this is highly prejudicial, it requires reversal. So I'd like to jump in. Oh, Judge Jones. You're muted.
Unmute, Judge Jones.
Oh, okay. How could the jury have thought that Mr. Diaguero had a history of domestic violence when the expert made clear on a number of occasions that she didn't know anything about the case, didn't know the parties, hadn't talked to anybody about the case, hadn't reviewed anything about the case?
As was recognized recently in People v. Cooper, this sort of testimony inherently invites the jury to fit the facts into the case. That's why it's very important under Martinez and as was recognized in Cooper that there's this link between frame of reference testimony and the facts in this case. I think I'd like to use sort of an analogy to illustrate the problem with this kind of testimony. So let's say that your friend is a really good tennis player and she normally has this 99% accuracy on her serves. And she's telling you this story about one day when all of her serves were really, really off. Like some of them were not even on the court. She was really frustrated. So she said, I went to an expert in how weather conditions can impact tennis. And she told me that wind 9 times out of 10 will do this to your serve. And you say, wow, like it must have been a really windy day for your serve to be that off. And your friend says, no, it wasn't even windy at all that day. You, as the listener, assume that it was windy, that's why she's telling you this story. And that's the story that the prosecution's presenting essentially with this expert testimony.
Counsel, I apologize for interrupting, but you say that in Cooper, you have a nice calm day, but here we at least have a breeze because what we have that we didn't have in Cooper is the recantation. And at paragraph 30 of Cooper, Judge Berger really emphasizes that distinction of the lack of a recantation, because you don't dispute that she recanted. There's just differing theories to explain her recantation, right?
So my position is that whether she recanted is really a question for a jury. Whether she's telling the truth at trial, that was the defense theory of the case, is that she was coming clean at trial. However, the recantation itself, and that's another problem with this testimony, is it suggests that the recantation itself is evidence of this cycle of violence, but really the recantation, you have to have a domestic violence victim before you can extrapolate that this behavior is consistent. Again, like you're missing that key link between this frame of reference testimony and interpreting the behavior that you're seeing. You're missing the wind. If without that, it doesn't. It's like looking at your friend's bad serve and saying it must have been windy that day. And the breeze analogy, insofar as
Judge Jones.
But it sounds like if we followed that theory, then recantation testimony by a blind expert would never be admissible, because you're saying, well, that assumes certain things and it proves itself, et cetera. But throughout the country, courts have recognized the admissibility of this testimony, including this court on numerous occasions.
I think that this testimony would be admissible in a case where there's some evidence of a cycle of violence. A prior incidence of violence would be a very easy way to justify the kind of prejudice that flows from this sort of expert testimony. Because the problem when there is no history of violence is the prejudice is just so high. It's encouraging the jury to make this propensity argument without any basis. Whereas when there's some evidence of some sort of dynamics of power control and a cycle of violence, then that prejudice is not so unfair. Here, it's deeply unfair because there's not this history.
I'm sorry, I feel like this question, it may in part be repetitive, I guess going back in some respects to Judge Walling's question about distinguishing Cooper with this fact of the recantation. But I want to go back to that because it's not just in the Cooper case. There's a series of cases from our court on recantation or reasons for recantation being admissible. And my recollection is at least one of those involves just one incident of violence. So how would you distinguish those authorities here?
Yeah, so it sounds like you're thinking of Lafferty and Wallen and Johnson. Lafferty is the one. Lafferty, I think, is distinguishable on two grounds. In Lafferty, that domestic violence expert testified that the cycle could occur in a single incident. There wasn't any similar testimony here, and I don't know how reliable that testimony was in the first place. I also think, if the prosecution manages to elicit that kind of testimony, this might be more reliable. Also in Lafferty, there was a limiting instruction. That seems particularly important when there is no history of domestic violence in the relationship or this kind of cycle. And then, sorry.
I'm sorry, finish your answer. I'm sorry, Ms. Winkelmeyer, when you're done.
I was just going to say, then you will need to disagree with Wallen, but you aren't bound by Wallen. It doesn't have much analysis, but I think it relies on that same problematic link. And then cases like Johnson, there was a basis, there was some history of violence. And when there is that link, the evidence is not so unfairly prejudicial.
Counsel, did you make a 404B objection to this? Because part of Judge Berger's analysis in Cooper is that this needs to go through the rubric of SPOTO because it sort of has an implicit prior bad acts to it. Did you specifically make a 404B objection?
There was no specific 404B objection, but that again sort of illuminates the problem in this case with the speculative nature of the implication, because the objection would be to sort of the implication, and it certainly wouldn't meet a 404B analysis. The prosecution wouldn't be able to satisfy by a preponderance of the evidence that there was any prior bad act because there wasn't one in this case. That it wouldn't come in.
But we don't know that, right? I mean, assume that we found, or I'll speak for myself, assume that I find the 404B analysis in Judge Berger's case persuasive and not necessarily distinguished by the recantation part, that it stands alone separate from the recantation. Don't we review whether or not it should have been kept out on a 404B ground as basically an implicit prior bad act? Don't we review that for plain error? And how can we find plain error here under the circumstances given when Cooper was decided and the ground that it broke?
If you were to analyze this under an implicit 404B analysis, I mean, I think it would be an obvious error because you wouldn't have there would be no preponderance standard that wouldn't be satisfied. As for the substantiality of the error, it would seem to be the same. You would you don't need to rely on Cooper to get here. I think Martinez, Valdez, Wilkinson, they all recognize this foundational requirement, this requirement that this link, particularly Martinez recognizes that you need this inferential link. And as I just said, the plain language of the 404B under SPOTA, you need this preponderance, which simply couldn't be satisfied to let this evidence in under Garner. Then
the 404B analysis that Judge Berger went through, that to me seems fairly unique to the Cooper analysis, that is not something that you find elsewhere. I mean, it maybe comes out of the same genesis, but really the requirement that he seems to impose that for this sort of evidence it requires 404B seems to be something that I can't find a basis prior to Cooper. Is there one that really cited it as a 404B problem? And if not, how can it be obvious?
I guess maybe I'm not following. So you would use Cooper to say that this is an error under 404B, or Cooper makes this error obvious under 404B?
All I'm saying is that one of the grounds that Judge Berger identified as a problem is that it essentially was 404B evidence without going through a 404B analysis, and that seems to have some legs on its own, independent of the recantation issue. But I'm trying to figure out if the court was in a position to figure that out. I mean, is it an obvious error that the court should have flagged? And are we reviewing that for plain error or not? If that's the part of Cooper that we find persuasive and still applicable.
Certainly. So I'm still not sure I follow. I guess I think that Cooper says, that this was obviously error under 404B because none of the procedural requirements for 404B were met. So that seems like an obvious error that the court should think that it's 404B. I think maybe that sounds like what you're wondering, like how that would be flagged for the court, that this is implying the prior bad acts. I think, again, all of the case law that predates Cooper would support that. Martinez flags for the court that it should have thought about fit, and then Castillo and Kaufman, which are cited in Cooper for this idea that the jury is going to try to fit the facts of the case, should have flagged it. And counsel made a relevance objection, which should have also, put the court on alert that maybe this wasn't inadmissible, even if not under 404B grounds.
Okay.
I'd like to just take a moment to talk a little bit about the prejudice that stemmed from this. Not only is it propensity evidence, but it was bolstering. It bolstered Ms. Boykin's first version of events. It essentially vouched for her first version of events as true. A particularly problematic piece of that testimony was when the expert said that I believe it was like 96 to 98% of these reports are true. And she said, yeah, you see some recantation in that 2 to 4%. That's exactly the kind of percentage testimony which was found in Mark's to be plain error, that it essentially vouched for one version of events, and that's improper. In addition, to return to an earlier point, yes, Judge Joe.
Counsel, did you raise the 96% testimony in your briefs?
Yes, I mentioned that in the reply brief, and I cited Mark's.
Counsel, I think you only mentioned that as part of your harmfulness argument, though, right? I mean, you haven't raised that separately as a substantive issue.
Correct.
Okay.
In addition, to return to your earlier comments about using the recantation testimony as evidence of domestic violence itself, that's exactly the argument that the prosecutor made, and that was really problematic. Because the recantation itself can't be evidence of the domestic violence. You need the cycle, you need the power and control before you reach, before you can say that the recantation is consistent with domestic violence testimony. And I'd like to reserve, if there are no more questions, I'd like to reserve the remainder of my time for rebuttal. Thank you.
Very good, thank you, counsel. For the people.
May it please the court, Carmen Morales on behalf of the people, my attorney registration number is 34852. So the expert testimony here was properly admitted because this was a domestic violence case where the victim recanted and wanted to reconcile with the defendant, which is part of the cycle of violence the honeymoon stage. Something that the prosecution also argued. Expert testimony, blind expert testimony, helps the jury to understand the dynamics of domestic violence and to more objectively assess the victim's credibility in the context of her recantation and also reconciliation desire, which are counterintuitive behaviors after an assault. Cooper's holding that there must be almost a perfect fit between the blind expert's testimony and the facts is incorrect, and this court should not follow it. First of all, Cooper is now before the Supreme Court together with companion case, People v. Coons, an unpublished opinion for this court. But Cooper is wrong because the very nature of a blind expert is that the expert doesn't know the facts of the case and is instead called to explain the general concept, dynamic, and topics that may be useful to the jury in understanding the evidence introduced at trial. Cooper is also incorrect because it speculates that the jury is going to find or infer prior acts of abuse or assault based on the expert testimony, despite the jury being told that the expert doesn't know anything about the facts of the case, and also being told that he doesn't know whether those behaviors occurred or not. In any event, as your honors were noting, Cooper is distinguishable because there the victim did not recant and the victim did not want to reconcile with the defendant. The two counterintuitive behaviors that necessitated the expert testimony in this case.
Counsel, for the expert testimony to be relevant, isn't there a predicate to that there has been some history of domestic violence? Otherwise, what is the relevance of this if there has been no history of domestic violence between the two combatants?
In a domestic violence case, like this case, particularly when you have a victim who has recanted and a victim who wants to reconcile with the defendant, I think that makes it relevant to offer a blind expert testimony to explain or educate the jury about the about the dynamics of domestic violence. So that makes it relevant.
Now, this is the concern that I have, is that you're actually using the expert's testimony to establish the predicate. In other words, you're using the recantation itself to establish the prior bad act. And that to me is problematic and poses the problem that Judge Berger described in paragraph 42 of here, that this is now evidence of a prior bad act. To be admissible, you have to go through the threshold step of SPOTO, which is established by a preponderance of the evidence that the prior bad act did occur. Then you can bring in the evidence and it's the jury's call and the like. But here, what's the predicate that this is at all relevant, other than the recantation?
Okay, so let me ask or see if I understand your question. There wasn't any evidence of any prior acts of domestic violence prior to this incident, right? The expert testified generally as to the power and control wheel, and then the cycle of violence and the recantation, generally as a blind expert. The fact that the expert testified generally as to that doesn't mean that, you don't need a prior act of domestic violence to convict of domestic violence.
No, but here's my concern, is that the expert is there to explain why a victim may recant. And the reason that the victim may recant is this cycle of violence. But here, we don't have any history of violence. Instead, we are using, or the jury may be in a position to use the recantation itself as evidence of a history of violence. So the recantation lays the predicate for the history of violence, which then in turn explains the recantation, without ever having established the predicate relevance of the expert's theory by at least a preponderance of the evidence, which SPOTO would require if we were to put this through the 404B rubric. I hope I'm not confusing things too much, but I'll give you a shot.
I do not believe that a history of prior violence makes the recantation or is necessary to make the recantation testimony relevant. The recantation testimony is relevant because this is a domestic violent case where there was an assault, overwhelming evidence of an assault upon the victim, and then a victim who doesn't, or who testifies at trials and completely recants, and also you have a victim who wants to reconcile with the defendant. Those behaviors are counterintuitive, and I think that having an expert who explains to the jury why that might happen, it allows the jury to more objectively assess the credibility of the victims. I do not think that you need prior acts to make that recantation testimony relevant, and that's the Lafferty case that you were talking about before. So I don't think you need prior acts separate from the incident that gave rise to this case to make that testimony relevant.
I'll ask a related question. I mean, what about, can you parse them out? I mean, can you provide the recantation expert testimony without the cycle of violence and some of the other expert testimony? And if so, was the recantation testimony perhaps okay, but some of the other testimony maybe without relevance or foundation?
Since I think that if a blind expert is limited to only portion of what a subject covers, say for example, here we have the three general areas, the power and control wheel, the cycle of violence and recantation, and only talks about one, I think the expert is going to be providing incomplete information to the jury, which is going to be misleading and ultimately is not going to be helpful. And if we limit blind expert testimony to whatever the facts of the case, the expert is no longer going to be a blind expert, and is gonna be problematic. I think is not really a matter of relevancy. I think when a blind expert testifies, they should testify about the whole subject. It's a matter of properly telling the jury that this is a blind expert that doesn't know the facts. And in fact, that's what juries are told. This is a blind expert. They don't know the facts. They don't know whether this happened. And also the juries are told you have to base your verdict on the evidence admitted at trial, which I think it minimizes any risk of prejudice to the defendant.
Can you address the concern about the percentages that were put on? You know, which version of events is more reliable, and why that isn't right in the heartland of vouching and bolstering that we're concerned about?
Okay, so I believe that the testimony about the percentages was elicited during the cross-examination. During the cross-examination of the victim, it was elicited by defense counsel. So they opened that subject. They brought it up, not the prosecution. In terms of the bolstering, I think even Cooper.
I'm sorry. They brought up what part of this? I'm sorry.
The testimony about the percentages of that the victims are telling the truth, or the recantation. Is that the question you were asking?
Yeah. So that wasn't the expert's testimony. That was during the victim's testimony.
Actually, no. You're correct. That was during the cross-examination of the expert. You are correct. Yes, okay. It was the defense. If I'm remembering correctly.
Okay.
Now, regarding the bolstering, I think even Cooper recognized that. I mean, to the extent that is some bolstering of the victim is acceptable, because the extra testimony is necessary to educate the jury regarding matters about which ordinary citizens either have no knowledge or not familiar with. So is a bolstering this is accepted and is recognized because it's necessary, and it's not an impermissible bolstering of the victim. unless there are any questions, I would like to touch a little bit about the harmlessness. Even if this court follows Cooper, which it shouldn't, because this court can distinguish this on the facts, it should find the error harmless. Defendant argues that this was a close case. This was not a close case. There was the evidence on the defendant's guilt was overwhelming. It included the victim's physical injuries, her 911 statements, which were pretty telling, her statements to Officers Gallegos, her statements to Officers husband, all corroborated, all consistent, and also her urgent text messages to her friend right after the assault. In contrast, we have just like a single cut to his finger, the injury that defendant sustained. And in addition to the evidence, as we talked before, the jury was told that the expert didn't know anything about the facts, and he wasn't bound by the expert testimony. And any prior acts of abuse is not an element that the prosecution had to prove. And so given the evidence, the instruction in the admonishment that the jury received, there is no reasonable probability that the expert testimony could have contributed to defendant's convictions. So unless there are any questions, we ask that defendant's convictions be affirmed. Thank you.
Ms. Winkelmeyer, I believe you have 1:37 remaining.
Thank you. So I just want to take a quick moment to address the Attorney General's argument that this is relevant to the domestic violence charge. I think I sufficiently addressed this in the reply brief. They're simply, the sociological concept and the statutory concept are quite different, but I also wanted to point out that the domestic violence finding doesn't need to be found by the jury, so sort of judicial evidence really wouldn't need to go before the jury. It's not required, it's not an element, which suggests further its irrelevance. But I wanted to try to tackle a little bit that 404B argument again, and maybe why it would be flagged for the court. I do think generally we are all aware that propensity is not the foundation of our criminal justice system. We want people to be tried based on their acts and not based on what they've done in the past or what they might do in the future. And all of our defendants have the presumption of innocence. So even if the court maybe didn't think of 404B, certainly this sort of propensity evidence should have flagged something for the court to worry about it. The AG also emphasizes the blindness of the expert's testimony, and I think I might have touched on this on my initial statement, but that they want it to be relevant for a counterintuitive statement, but then they want it to be harmless by saying it's unrelated to the counterintuitive facts. But you need that link for it to do anything for the first point. I also wanted to point out Lafferty and Wallen predate Martinez, and the response from the expert that gave the statistics was not responsive. Defense counsel was just asking whether it applied outside of domestic violence cases. Thank you so much. And we would ask that you reverse based on issues 1 and 2, merge on issue 3, and correct the minimus on issue 4.
Thank you, counsel, for your fine arguments. We appreciate your briefing in the case, as well as your flexibility and cooperation with this new process. You both did wonderfully this afternoon, and we appreciate it. With that, this case will stand submitted, and a written opinion will issue in due course. We have one more case on our afternoon docket, but we're going to be recomposing the division. So we're going to take a quick break, and we'll be back. Thank you, counsel. Mr. Hunter.
Good afternoon. May it please the court. My name is Cameron Hunter, attorney registration number 50095, and I represent the plaintiff on appeal today. This is a case for personal injury arising out of a motor vehicle collision in which plaintiff suffered catastrophic injuries. Following the collision, the parties engaged in settlement negotiations, and when a dispute arose as to whether a valid settlement agreement had been reached, the trial court ordered that the trial be bifurcated so that the parties could litigate the issue of contract formation first. Following trial, the jury determined that.
Mr. Hunter, can you just answer a quick question for me? Had the jury concluded that there was no settlement agreement, were you going to roll into the damages and liability phase immediately with the same jury, or was it going to be separated to tried to a separate jury later?
My understanding is it was completely separate. It would have been a separate jury.
Okay, I was having a little trouble with that from the record, and it's probably my fault. Thank you.
No problem. Okay. So while plaintiff argues in favor of 4 different grounds for reversal in the briefing in this matter, with this court's permission, I will focus primarily on 2 of the arguments we raise. I'll argue today that the trial court erred in denying plaintiff's motion for judgment notwithstanding the verdict first, because State Farm's purported acceptance of plaintiff's offer constituted a counteroffer as a matter of law. And second, because State Farm cannot be said to have complied with the second condition of plaintiff's offer as a matter of law, which required State Farm's due diligence in determining whether there was additional potentially applicable insurance coverage. So turning to the first of these 2 arguments then, State Farm's alleged acceptance of plaintiff's offer was in fact a counteroffer. Beginning with some familiar legal principles, a court may enforce a settlement agreement only if it constitutes an enforceable contract. A valid enforceable contract is formed only when an offer is made and accepted and the agreement is supported by consideration. When the recipient of an offer provides a counteroffer rather than an acceptance in response to that offer, this serves as a rejection of that offer. And when an offer is rejected, it ceases to exist and of course cannot thereafter be accepted. A communication constitutes a counteroffer rather than an acceptance if an offeree makes changes in any particular to the offer and its purported acceptance. The changes need not be substantial or material to make an alleged acceptance a counteroffer. In this case, State Farm responded to plaintiff's March 6, 2018 offer of settlement with a letter dated March 19, 2018. In that short 4-sentence letter, State Farm represented 3 times that its letter was a settlement offer and requested that plaintiff's offer discuss this policy limits offer with his client. The letter did not anywhere indicate that it was an acceptance of a previous offer. The letter did not anywhere indicate that it was an acceptance of a previous offer, and did not anywhere mention, plaintiff's offer of settlement. And while the letter contained a brief reference to plaintiff's request for an affidavit from Dulal, the 3rd condition of plaintiff's offer, it nowhere mentioned the other 2 conditions upon which plaintiff had predicated its offer, that of documentation verifying policy limits and verification that State Farm had performed its due diligence concerning whether there was other potentially applicable insurance coverage. In their answer briefs, neither State Farm nor Dulal directly responds to these points. Yes.
In addressing this issue, should we consider only the letters sent by Mr. Sidley's counsel and the responses from State Farm, or should we also consider the evidence before the jury?
Your Honor, I'm not sure that you're prohibited from considering the evidence before the jury, but it seems to me that that's not necessary. It seems to me that this is a strict question of interpretation. What did plaintiff's March 6th letter say versus what did the subsequent March 19th letter say? And it's clear that if plaintiff's letter is considered to be an offer, which I think it is, it's clear that the March 19th offer, which was purported to be a response to that, was obviously not an acceptance, was obviously a counteroffer. And thank you, Your Honor. I'm sorry that I missed your hand right when you put it up. In any event, what State Farm argues in response is rather than addressing plaintiff's points, State Farm argues simply that this was not a counteroffer, but argues rather that this was a confirmation of a previous offer. Which, I mean, the first and most obvious response to that is that a confirmation of an offer is still just that, it's still an offer. And as just mentioned, an offer given in response to another offer is, of course, a counteroffer. Moreover, State Farm's argument highlights precisely why this letter constituted a counteroffer rather than an acceptance. State Farm's offer was an offer to settle in exchange simply for policy limits, whereas plaintiff's offer, by contrast, was an offer to settle for policy limits provided that 3 additional conditions were complied with. And so by extending an offer that restricted State Farm's obligations to the mere tendering of policy limits, this turned that purported acceptance into a counteroffer. Yes, Your Honor. Oh, Your Honor, I can't hear you.
All right. You concede that a party can accept an offer by performance. That is and in this case, by satisfying the conditions of the offer.
And sorry, I missed the very first part of that. Your question was, do I agree that?
Would you agree that a party can accept an offer by satisfying the conditions of the offer?
Sure, Your Honor. It's my understanding that substantial compliance, for example, can be a way of accepting a unilateral offer to contract. The problem is that this letter, the March 19th letter, preceded any attempts by State Farm to comply. For instance, when State Farm eventually sent verification of its policy limits, which was called for by plaintiff's offer, and the other steps that it took, that all came after this March 19th letter. And so, oh, yes, Your Honor, please.
Yeah, so that's true, but then why didn't someone on your side say, hey, what are you doing? We don't have a contract. We haven't accepted your counter offer, instead of just accepting what they gave you. Not just accepting, but they said, do we need to provide anything else? And you didn't even respond.
Well, eventually we did, Your Honor. I don't know.
By filing a lawsuit.
Correct. Correct. Yeah, the March 19th letter we interpreted to be exactly what it is, a counteroffer, which was a rejection of plaintiff's offer of settlement, and plaintiff was under no obligation to course correct State Farm's rejection of its offer. So if that answers your question.
Counselor, I got a kind of related question to Judge Jones. So certainly this is not a magic words issue, right? If I say, I accept your offer and with the following 3 conditions, that's not an acceptance, that's a counteroffer, even though I use the word acceptance, right? You say I accept and that's a counteroffer, even though it's couched in terms of an acceptance of an offer, right?
I'm sorry, repeat your question, Your Honor. I'm not following it.
If I respond to an offer and say, I accept your offer with the following conditions, that's not an acceptance, that's a counteroffer. I use the language of acceptance, but it's counteroffer, right?
Correct, Your Honor.
Then why doesn't the same analysis apply to the letter that was sent? And it's a question of whether or not there were any changes to the terms of the agreement. And that gets back to, I think, what Judge Taubman was asking about, which, why isn't this a question of fact for the jury to determine whether or not there was any material change and whether or not they acted in conformity and complied with the terms of the offer? And in assessing that, we have to draw all inferences in favor of the jury's verdict. And you're not challenging that they weren't properly instructed on what an offer versus acceptance versus counteroffer is, right?
Correct, Your Honor. So
can
let me, please, yeah, let me go ahead and respond to your questions. I'll try to take those in the order that you posed them. So the first question was, if this isn't just a magic language game, obviously our argument can't ride completely on the fact that this letter referred to itself as an offer. And I agree, Your Honor. I don't think the fact that it referred to itself as an offer 3 times by itself makes it an offer. I think that's one of the factors to be considered. And so then to your second question of why does this not remain a question of fact for the jury? One of the bedrock principles that we have in Colorado is that while typically the issue of whether a contract exists is a question for a jury, that's only if the evidence is conflicting or admits of more than one inference and one view of the evidence would support the existence of a contract. We don't have that here. All the cases that I have found that discuss interpretation of whether or not a purported acceptance constitutes a counteroffer turns on whether or not there were material changes. And here, there absolutely were. As a matter of law, plaintiff's offer said, we will settle for policy limits provided you comply with these 3 conditions. Defendant's or State Farm's letter in response says, we offer to settle in exchange for policy limits. There was a sentence that mentioned, sorry.
What's the difference? I'm sorry. They're saying meet these 3 policy limits, but also meet these 3 conditions. And their letter back said, yeah, we'll settle for policy limits and we're going forward with getting you all the documentation to satisfy your conditions. What's the material difference?
Is that 2 of the 3 conditions are completely omitted. So there's a throwaway sentence at the very end of the letter that refers to the affidavit that plaintiffs have asked for, but there's no mention of the documentation verifying policy limits. There's no mention of State Farm making efforts to do its due diligence, which was the second condition of plaintiff's offer. The risk here is that the March 19th letter invited acceptance, as an offer does. Rather than an acceptance. And the worry here would have been that if plaintiff had sent an email, for instance, to that saying, okay, we agree, then it seems like the parties would have had a contract that would have provided plaintiff with the policy limits and potentially the 3rd condition, which referred to the affidavit, but would have been bound to have to forego the 1st condition, which was verification of policy limits, and the 2nd condition, which was verification of due diligence.
They couldn't have just sent back a letter and said, we accept. The terms of the offer were, you have to accept through conduct. You have to do these 3 things to accept, and you have to do it within 30 days. So essentially, we're leaving this offer open for 30 days, do these 3 things within 30 days, and we've got a contract. And this was sort of step 1, and said, we're working on the other stuff, and you'll get it within the window. And in fact, did.
Sorry, Your Honor, I didn't mean to speak over you. And certainly that's where plaintiff would disagree, is that this wasn't the first step. This was the functional equivalent of if State Farm had written back saying, no, we're not going to do that, and then had later sent the documents along. In plaintiff's view, no, the rejection terminates the offer, and that's exactly what happened here. The offer was a counteroffer and functioned to terminate plaintiff's offer regardless of whatever State Farm did next. Had State Farm simply began the process of complying and performance, then yes, those would have been the steps to acceptance, but this letter functioned as a counteroffer and functioned as a rejection. And so, Your Honor, I see that I'm just 3 minutes. Unless there's any burning questions, I would like to reserve the remainder of my time for rebuttal, if that's okay. Oh, yes, Judge Jones. Oh.
Okay, I do have a burning question.
Okay.
And that's on the 2nd condition.
Yes.
The 2nd condition called for a verification, okay? I know that sometimes we can get a little hyper-technical, but that has a particular meaning to me. It means basically you're swearing that this was done. And that was done in this case. I mean, they swore, they had an affidavit from their client, there is no other insurance. And we have looked at this, and there is no other insurance. It doesn't call for the production of evidence supporting their investigation. It just calls for a verification of no other insurance.
Your Honor, and so if I'm understanding your question, I would disagree in terms of the language of plaintiff's offer of settlement. Specifically, the wording is, Your Honor is right to focus on the word verification. It does say that, verifying that you have done a due and diligent search. And then the next phrase indicates what's required to be produced to plaintiff, which it states, including reasonable communication with your insured and detail of what you have learned. So it's not only a verification, it's a production of information. Plaintiff's position is
that is not what that says. It says this is what you have to verify, and that's what they verify. They have to verify they did this investigation of these things, and that's what they did.
Your Honor, that's simply not correct. The letter it says.
Doesn't this at least illustrate that there is at least an ambiguity for the jury to decide?
Your Honor, we would say no on the issue of due diligence. This would be a situation where the court could conclude as a matter of law on the issue of due diligence separately from the issue of counteroffer. That 3 communications with an insured, someone who doesn't speak English, when 2 of those 3 communications were in English, and reliance on an affidavit that was improperly explained to the insured absolutely does not rise to the level of due diligence, would be plaintiff's position. And so I've got about 40 seconds. Again, if it's okay, I'll reserve the remainder of that time for rebuttal.
Very good. Thank you, counsel. And I try and remember who agreed to go first. So, all right, Mr. Patterson.
Thank you, Your Honor. Again, Frank Patterson. I represent the intervener, State Farm. And I'll just start right in on the counteroffer issue. Plaintiff argues that the March 19 letter from State Farm was a counteroffer. The jury was instructed on what was an offer, an acceptance, and a counteroffer. The jury was presented with a fact question as to whether State Farm's letter was indeed a counteroffer. Plaintiff counsel was permitted to argue extensively in closing arguments that the letter, in fact, was not part or step one of the acceptance, but that it was indeed a counteroffer.
Can you help me with a piece of the record here? There was before your client intervened, there was a motion and an order from the court that explicitly found that there was no binding agreement. Not just that it's a question of fact and it can't decide it as a question of law, but its order early on in the case said no binding agreement. How did we go from the trial court's order in that regard early in the litigation to a triable issue of fact?
Sure, it was presented to the court initially on a motion to dismiss under Rule 12. So when that court issued that order, it was for the purpose of determining whether under the requirements of Rule 12 that the court could enter judgment at that point. The court concluded that it could not based upon what was presented to it. But it's the same court that later said, I did not intend that to preclude discovery or admissibility of evidence that would later contest it. He was making those findings on what was before him at that time.
Where in the record did the judge provide that clarification that look, you're overreading my order? I just couldn't find it.
Well, and I don't have a cite to that. I recall it was at the pretrial conference where plaintiff first raised the motion in limine to preclude some of the evidence and talked about that. And I did not look back to find the citation to it, but I believe the trial court discussed it at that time and then when we were in the trial itself.
So that original order was just sort of overwritten as far as what it was deciding, and we can't take it literally.
I think the court was saying it was more in terms of dicta, and that he did not need to make that specific finding in a final sense, because he only needed to make a finding that at that point in the litigation, he could not grant the defendant's motion to dismiss.
Very good. Thank you for indulging me, counsel.
Sure. Now, plaintiff argues that the March 19 letter of State Farm is indeed a counteroffer, but I agree with the court that it was step one. Step one was saying, yes, we will pay our $25,000. And unless they're arguing about magic words by the use of the word offer, that somehow magically that was not part of step one of accepting, then the plaintiff's argument fails. There is evidence that was admitted in the case that plaintiff counsel themselves considered that part of the demand letter or the offer. In the exhibit, let me find it, Exhibit K was the April 13 email from plaintiff counsel's office. And it says, quote, "Are you tendering the policy? I've got your affidavit and confirmation of coverage, but I do not see a release or confirmation that you are actually tendering the policy." So even after the deadline had passed, and this is 8 days after the deadline had passed, plaintiff counsel's office considered the offer of the $25,000 to be step one, and they were wanting to confirm that that had happened. Nothing in that March 19 letter changed any of those three conditions, and that's where I think plaintiff's argument fails as well. It doesn't. Yes, Judge Taubman.
Mr. Patterson, I have a question about the March 19th letter that State Farm sent. If I recall, it says we're making an offer of $25,000 as opposed to saying we accept your offer that you previously made to us. Is there a reason that in the record that State Farm used the language that it did in that March 19th letter?
I don't recall exactly, but if there was, it's because it's a form letter. I think Ms. Hansen may have testified that they used the form letter, and that's why it says this will confirm our policy limits settlement offer in the amount of $25,000. Does that answer your question, Judge Taubman?
Yes, thank you.
Mhm. But again, it did not, nothing in that letter of March 19 changed any of the conditions that plaintiff placed in the original offer letter. In fact, the last paragraph of it talks about one of those conditions that State Farm was pursuing. If anything, it remained a question of fact. We think it was clear enough that the court could have ruled that this was not a counteroffer. But if anything, it was a question of fact for the jury to decide, and the jury decided after being fully instructed that it was not a counteroffer. And again, I said before, plaintiff counsel's office treated that letter as part and parcel, the offer of the $25,000 policy limits as part and parcel of what they were expecting State Farm to do. So again, as Judge Welling said, that was step one. That's all I have to say on the counteroffer argument. If I could address the other part for just a couple of minutes about whether the court improperly introduced the evidence. I want to point out that plaintiff is arguing that what State Farm did, the actual conduct it did for due diligence, was not admissible. Only what was conveyed to plaintiff counsel should have been admissible. We disagree with that because the demand letter or the offer letter actually required conduct. So State Farm was entitled to demonstrate to the jury that it performed as required by element number 2. Element number 2 was drafted by plaintiff counsel. Counsel argued in briefing that it should be reviewed de novo just as if it were a written contract. Even if that's the case, then the rules of construction for de novo review of the offer bind against the plaintiff. That paragraph number 2 is poorly drafted and poorly worded. As we can see, several of the panel members already understand that part 1 of that element is that you verify that you've done a due and diligent search, including reasonable communication with your insured. State Farm did that. Then the second thing they were asked to do is detail to us what you have learned about the possibility of other insurance. And State Farm did that. The detail they provided to them is there is no other insurance. Counsel would like to force a strained construction of that paragraph that they drafted. And it's ambiguous because they drafted it that way. They would like to force a strained construction that State Farm was required to convey to the plaintiff everything it did in due diligence, and anything they did not convey, and this is from page 2 of their reply brief, anything that State Farm did not convey back to the plaintiff should have been inadmissible because it was not part of element 2. Yet that's belied by a great additional part of the reply brief, pages 16 through 19. Plaintiff argues that State Farm was required to do a great deal of due diligence that it didn't. And I heard Mr. Hunter argue already today that part of what he wants to argue, if he has sufficient time, is that State Farm failed in the amount of due diligence that it performed. If in fact that's the case, then plaintiff has admitted that the evidence of what State Farm did was admissible. It was relevant. It was relevant to whether State Farm met that condition. So the additional pieces of evidence and testimony that plaintiff complains about in the opening brief is now in the reply brief something that plaintiff admits should have been done. They wanted to argue it was insufficient now, and that's why the judge correctly ruled it was admissible. One final point is that the trial court gave a limiting instruction. The law in Colorado is that
believe that the jury follows the instructions of the court. And in this case, the court gave a limiting instruction at plaintiff's request as to the evidence that plaintiff complains about. There has been no evidence, no argument that the jury failed to follow the court's instruction. If anything, even if we assume that the evidence should not have been admitted, it's harmless error because we can assume the jury followed the court's instruction and only considered that information for the limited purpose that the court allowed. Unless there are questions of me, I'll turn over the rest of the time to Mr. Meyer.
Mr. Meyer.
Thank you, Your Honor. Good afternoon. My name is Caleb Meyer, and I represent the defendant in the case, Rashawn Duvall. I want to start off, certainly my client, we certainly adopt all of the arguments that have been set forth by State Farm and Mr. Patterson here so far today. Because the majority of the conduct or communications at issue in this case did not involve my client, my role on behalf of Mr. Duvall and Mr. Duvall's involvement in this case is fairly limited. And in that regard, I want to focus on the contribution or the information relating specifically to Mr. Duvall or his mother in this case, and that's specifically relating to the affidavit that was asked to be provided in the representation as to the good faith estimate as to the personal assets that were available for purposes of plaintiffs' arguments that the judgment should be reversed on motion for judgment notwithstanding the verdict. There was significant evidence that was presented to the jury in the case of factual circumstances surrounding the Duvalls, and very specifically that they lived in a rented apartment. They did not own a motor vehicle, did not own any real property, didn't have a bank account, did not work, relied upon family members' Social Security income to pay rent for an apartment. And literally, Ms. Duvall indicated that the only possessions that she owned were several outfits of clothing. And
bed sheets, counsel.
I'm sorry.
And bed sheets.
And bed sheets.
Judge Taubman.
Yes, Your Honor.
Mr. Meyer, I have a question about Ms. Duvall's affidavit that she had no assets. If that's the case, does the record indicate in any way how she was able to purchase the policy with State Farm that's at issue in this case?
Your Honor, I don't recall off the top of my head specifically the answer to that question, or if it was even asked as part of the record. So I apologize. I don't know if that question was asked or if she even provided an answer to that effect.
That's fine. I was just wondering because it seemed anomalous that she would have no assets, yet she was able to buy an insurance policy from State Farm.
I understand, and I apologize. I just don't know whether there was even a question that was asked. I can't recall whether the question was even asked or answered during her testimony. But one of the
Counsel,
things,
does it enter into our analysis that what we're talking about, it appears to be the difference between zero and some nominal sum, but what was being looked for in the response was whether or not she had $75,000 or less in assets? Does that enter into the equation? I mean, it sounds a little bit like angels dancing on the head of a pin. Should she have said $5 instead of $0? It doesn't change the outcome of what was being sought.
No, you're exactly right, and I think your question gets to the end result, which is that whether she wrote $5 or $10 or $0 did not meaningfully or in any way affect the terms of the settlement for purposes of an enforceable settlement agreement. And what I think is important to also understand is that Ms. Duvall's understanding of what her good faith estimate was as to the amount of a level of personal assets, she equated that to value. What, if anything, do I have that's worth anything in value? And essentially she believed that even the clothes on her back and the 3 or 4 sets of clothes on her back and her sheets were essentially valueless. So if there's no other questions, I believe it looks like we're just about out of time.
Very good. Thank you, counsel. I think you've got about a half a minute left, counsel, for rebuttal. So take the floor.
Thank you, Your Honor. I'll try to choose wisely. I suppose I'll just address that very last issue that was just raised, and that gets, of course, to whether Ms. Dulal gave a good faith evaluation of her assets and whether it was reasonable for State Farm to take that at face value. And what the court had found, the trial court, in the order that was mentioned earlier, in the order denying defendant's motion for to enforce settlement agreement, was that plaintiff suffered catastrophic injuries here. And certainly he was entitled to be cautious and to make sure that he obtained what he asked for, which was not any specific dollar amount necessarily, but it was a good faith and reasonable offer or estimate of her assets. And I see that runs me out of time.
Very good.
Thank you.
Thank you, counsel, for your fine arguments and briefing on this. The case will stand as submitted and a written order will issue in due course. I appreciate counsel's participation in these evolving procedures and your willingness to give the time and effort to allow us to conduct the arguments under the circumstances that we're facing. So with that, that is our last case. So we will stand in recess, and everybody have a good and safe evening.